Hello, everybody, and welcome to this edition of MacroPro and Friends. I'm Diane Cohen with MacroPro, your host for the day. I am joined by Chantel and Sarah. Hello, ladies. How are you?
Good, thank you.
Well, we really appreciate you guys participating in our summer school series, and this has been the most registered for event of our series. So how did you come up with this topic? Because there are over 250 people that, want to hear about this.
Well, I asked my clients, I asked them, what's relevant for you? What is something you'd like to know more about? And this was the #1 topic amongst all of them.
Oh, fantastic. Well, what I think I'm going to do is I'm going to ask everybody that's online, if you have a topic you would like us to cover, can you put that in the question box for me? And then I will take all that information down, and then we can try to see if we can find speakers that will cover that. So thank you, ladies. I'm going to do real quick some housekeeping, and then we'll turn it over to you. So today's webinar is worth 1 CEU. Again, you have to be logged on to go to webinar. You can't just be phoning in. If you're phoned in, unfortunately, they cannot register your time and attendance. Your certificate will come within 2 hours of this broadcast. We do have handouts for you. That was one of the questions we have. So it is attached. So please sure to download that so you can use it for reference in the future. If you have any questions, please put them in the question box. And if we have time at the end of the presentation, I will ask those questions of our experts. And then lastly, you can always watch it again on the MacroPro YouTube channel. So MacroPro is a document retrieval company. If you ever need records, we're here for you to do that. Thanks very much, ladies. I'll leave it to you.
Great, thanks, Diane. Just a quick introduction. I'm Chantel Thomas with RTGR, and this is my colleague, Sarah. And we both work out of Southern California, and we cover all of the Southern California boards. So if you ever have any questions about the Southern California boards or Southern California Workers' Comp, feel free to reach out to us at any time. Our emails will be on the PowerPoint at the end so that you can reach out. Just our little legal disclaimer, this is not legal advice, this is purely for educational purposes. So please don't take this as legal advice. So today our presentation is on TD overpayments, and I would imagine most of you already know what TD is, but just to lay the foundation, since we are lawyers, we're going to start at the very beginning with what is TD. So if an employee has an industrial injury, and because of the industrial injury they lose time, then they're entitled for wage replacement benefits, which we call TD. If they are injured at work and they can work some, but they aren't earning their full wages, then they're entitled to TPD, temporary partial disability, which is just the differential between what they're usually making. I did include the labor codes here for the timeline for administration of TD benefits and the TD cap, just in case anybody wanted those in the future, but they're not really necessary for today's presentation. So what is a TD overpayment? It's just the difference when something happens that ends applicant's entitlement to TD, and then there's a delay between when the TD actually ends, usually because defendant isn't aware of whatever this event is, and that results in an overpayment of extra money to applicant. So then the question is, when do we see these? We see them when applicant is released to full duty by their treater. We see these when applicant is released to modified duty that the employer can accommodate, so then they're no longer entitled to TD. We see these when applicant is declared permanent and stationary, either by the PTP or the QME. We see this if they reach the 104-week limit. If the applicant, if we're past the 5 years since the date of injury, applicant's only entitled to TD benefits for 5 years after the date of injury. So once you hit that 5-year mark, no more TD. And then the last situation is if TD is paid incorrectly. So the first issue, I guess, with TD overpayments is how do we prevent them in the first place so that we don't have to try to go back and get a credit. So in order to go through this, I'm going to go. I'm sorry? I thought I heard someone ask something. So I'm going to go through each of these situations where we see a TD overpayment and then discuss how we might be able to prevent them in these situations. So when applicant is released to full duty or is released to modified duty that can be accommodated, the best way to prevent these resulting in a TD overpayment is to find out about them as soon as possible. And we all know that the PTPs don't always get us the work statuses right away, or we don't find out about it until after the fact. So the surest way to stay on top of it from an adjuster perspective, or even as a defense attorney, is to set diaries. We set a lot of them to stay on top of things. So if applicant was seen by the doctor, we know they're going to have to be seen 6 weeks later. So you take the date of the appointment, you set a diary for 6 weeks, and you make sure you get that work status note from the doctor, or even a verbal over the phone of what's going on. So if they're released, you know, and you know to end TD and follow up for that note. Another way to do that too is to stay in close contact with the employer, because sometimes, even though the doctors aren't quick at providing these notes, sometimes the applicants are really on top of it and they take the notes into their employer, or they send them into the employer. And so then the employer sometimes will get them before the TPA. So if you're in close communication with the employer, then you're going to be, you know, in the loop. Okay, hey, they've got this work status note and they've been released and they're coming back, or they got this work status note and there's modified duty and the employer can accommodate. It's also important to know if the employer cannot accommodate so that you can continue with TD. So really the best way is to just stay on top of the dates and stay in communication with the employer and the doctor, because those are the things we can control. We obviously can't force the doctor to give anything any faster than they do, but bugging them sometimes helps. So then the next way, or the next situation that we see a TD overpayment, is when applicants declared permanent and stationary. And this is the most common situation where we would see a TD overpayment where we might actually get a credit. And this occurs when applicants declared permanent and stationary, but then we don't get the report. So particularly with the QME, you know, applicants evaluated on, say, May 1st, we know the QME has 60 days to issue the report. So now July 1st rolls around and we're getting the report, and the QME says, oh yeah, they were PNS'd on the date of the evaluation. So now there's a 60-day time lag that you were paying TD. And then there's processing time involved in that. So how long does it take to get the report processed through the TPA system? How long does it take to get it processed through the defense attorney system, get it rated, figure out what's going on? And so sometimes that could even result in even more than a 60-day overpayment. And so, I mean, in that situation, the QME is by law allowed the 60 days. So there's really nothing we can do to get that answer sooner. The only thing we can do is to just stay on top of administrating it as soon as we get it, so that there's no fault of defendant in the resulting overpayment. And then the other thing is, if the PTP declared them permanent and stationary, we typically get those quicker, at least through the work status. A lot of the times we will get a work status, or we'll get a verbal from the doctor saying, oh yeah, they're PNS, PR4 to follow. Well, so in that situation, we know they're PNS, we just don't have the details, and you can end TD and send out a PD monitor notice and then continue to follow up with the PTP until you get the PR4. And so also, you can end up with a bigger TD overpayment issue if the PTP declared them permanent and stationary, and then there's a long time lag, we object, we get a QME, the QME sees them, and then the QME adopts the PTP's date. That's great for some, you know, for cutting down retro TD exposure, not so great if you were paying TD the whole time. So that's something you would want to address on a fact-specific basis. But if the PTP's report is substantial, you're going to want to cut off TD with the PTP PNS date, so that if the QME adopts it, you don't have a massive overpayment. Another thing to keep in mind is that high wage earners rack up really large TD overpayments much quicker. So if you know you have a high wage earner, that's when you're really going to want to pay attention to the diaries and the communication on, because the TD overpayment will get big quickly. So then this is the one that I'm sorry, what was that?
You were echoing somehow. It's not somebody else speaking.
Oh, I'm sorry. So this one is the one that we can control the most because this one is related to the administration of the benefits. So all three of these are, which is why they're grouped together. When applicant reaches the 104-week limit, applicants beyond the 5 years, or the TD rate is calculated incorrectly. So all three of these can be controlled by defendant. So these are the ones that we're going to want to make sure we don't mess up on. These are things with setting your diaries for the 104-week limit, double checking and recalculating. The 104-week limit is easier to catch when you've been paying TD for 2 years straight. But when it's broken periods, like we paid a little, they went back to work for a little bit, then they're off a little bit. Those are the ones where it's more difficult to keep track of the weeks. And then sometimes we overpay. So we're just going to want to keep track of those, work with your supervisor, work with your defense attorney. Everybody can double check the numbers, and everyone working together will help prevent any errors so that there's no fault of defendant. We will talk later in the presentation about how that's weighed. So if there is fault on the part of the defendant, you're not going to get the credit. So you want to control what you can, which in this situation are these three things are all within our control, whereas the QME report is not. So then next, what do we do if there is an overpayment? Do you just, applicants declared permanent and stationary, we're going to start advancing PDAs, so we're just going to take the credit? No, definitely do not do that. I know we used to do that, but effective January 1st, 2020, the board adopted CCR 10555, which says you have to file a petition for credit, and the petition for credit has to be adjudicated. So you can't take a credit until the credit has been ordered. So if you unilaterally take a credit against applicant's permanent disability without a petition for credit and or an order, you can get penalties and sanctions for that, and we don't want that. So do not just take a credit automatically. So this is a case that addresses it, but interestingly, this case is back from 2013. So in this case, defendant took a credit unilaterally for a TD overpayment, and back in 2013, the judge upheld this based on the principles of equity, saying, well, it's not really fair for applicant to get this windfall at the credit was a little over $17,000. And so the judge said, yeah, we're going to uphold it. Applicant appealed with a petition for reconsideration, arguing that the judge could not amend the original award because there was a findings and award at trial that didn't address this. And the WCAB upheld that defendant improperly took the TD overpayment credit. And it was all based on the fact that the credit was not included in the original award. So that, like I said, this case is from 2013, so it was before the 2020 reg, but it even supports that there has to be some adjudication, and it is in line with the now regs. So if you have to file a petition for credit, how do you do that? What do you have to include? So under CCR 10555, it has to include the description of the payments, a description of the benefits against which defendant seeks credit, and the amount of the claimed credit. So breaking this down, this is saying we paid TD from X date to X date at a rate of $500 per week, and then for a total of $15,000. Then applicant was declared permanent and stationary on this date, so there's a TD overpayment period from X date to X date in the amount of $500. And then we're seeking a credit of $500. So you just have to lay out each one of those things. I included an example petition in here so that you could see how we do this in practice. I removed all of the personal information, and all the numbers and dates are completely made up just for you to be able to see. You'll want to be sure you include exhibits so that you can show when you actually paid the benefits, when the TD ended, what the TD overpayment is. And then, like with all pleadings at the board, you want to be sure you include a verification. If you don't have the verification in a pleading filed with the board, it will be automatically denied. So if you want to ensure that your petition for credit is addressed on the merits, be sure you include a verification. So it's a pretty simple pleading. As you can see, it's short. You just lay out the basics of the details and ask for the credit to be ordered. As a practice tip, I typically include a proposed order already ready for the judge to make it easy, but some of them use them and some of them don't. So it just depends on the judge. And now Sarah's gonna take over and talk a little bit about the petitions some more.
Sure. So the next question we come to in this process is, when do we file the petition? None of the regulations or statutes tell us a specific timeline or date, but what we really are concerned about is notice to the applicant of the facts and basis for your claim for credit. And so it's, best practice, and the case law says to do it as soon as a dispute arises as to a credit for any overpayment. The case where we get this rule, Ramraka, the defendant didn't file their petition until the date of trial, and it was actually found and upheld that that wasn't too late, but it's better practice to not take it that far and not let it go that long. So it's really a matter of keeping track, paying attention, knowing when do you have a problem, and if you do have an issue with you're going to be seeking a credit, to at least be in contact with the other side and have them be aware that that is a petition that is coming, and that there's, so that they're on notice. Next, so what are they actually looking at when the judge is considering your petition? What are they considering? And it's really in their discretion. Labor Code section 4909 provides that it's totally up to the discretion of the judge to grant or deny the credit for overpayment. Excuse me, the Cordes case tells us the same thing. It's not the intention for there to be a harsh dictate that avoids the equities presented. And then the purpose of 4909 is to encourage employers to make voluntary payments to employees in appropriate circumstances. Then after, they'd be able to collect the credit because they want to. And the purpose of the law is to encourage the defendant to pay even where it might be iffy, and that they can rely on later being able to seek the credit. Okay, so the primary consideration, it's equitable. So the factors that we consider, or the judge considers, is the impact that the credit is going to have on the employee's benefits, including, this is an important one, whether the overpayment credit would wipe out the permanent disability recovery. Next, most important consideration is going to be whether there was negligence or fault that resulted in the overpayment itself. Excuse me. So, and then finally, whether granting the credit would be in contravention of the underlying purpose of the Workers' Comp Act. So that we get that last rule, or just consideration, from the Maples case. And so in this case, the case tells us that, it's often understandable, what Chantal touched on before, that there can be a brief delay between a report being issued and, there being being able to respond to the report by ending TD. So there's, naturally just going to be an overpayment there. There's not too much we can do about that. And so in those instances, it makes equitable sense when there's no fault for the defense to get a credit. In this Maples case that we had, the facts actually were very different. The defense had reports for declaring the Sorry, did I hear someone? Is someone, I don't think people are going to be asking questions, but I heard a voice. Maybe not. Okay, so in this case, it was very different than that sort of small window where there could be some overpayment, because in this case, there was a report that the defense had that declared the applicant permanent and stationary, and it was not turned over for 10 months, and there was significant overpayment for that reason. And so in this case, going back quickly to another consideration that the court took into account was whether the credit would be in contravention of the underlying purposes of the Workers' Compensation Act. So I don't think this is new information to anybody, but we'll just go over it quickly. Temporary disability indemnity and permanent disability indemnity were intended by the legislature to serve totally different functions. TD serves as a wage replacement during the injured worker's healing period for their industrial injury, versus permanent disability, which compensates them for their residual handicap and impairment of function. So the PD serves to assist the injured worker in his adjustment and returning to the labor market. So sometimes if a credit is granted for a TD overpayment against PD, it can disrupt or even totally destroy the purpose of PD, and that's a consideration that judges are very much looking to, and preventing if it is the case that that granting the credit would just eliminate PD and therefore eliminate the purpose of PD, and it's very unlikely that the credit would be granted. Right. Let's see. Okay, and next we have the Verden case. So this is just an example that it's an example of one of the situations that Chantal talked about earlier, where it is something that is in more in our control, where in this case the credit was ultimately denied because the TD overpayment was a result of the defense paying paying a higher rate than they should have, and there was evidence submitted that it was clear to the defense that the applicant was receiving rate payments at a higher rate than they should have early on, and they didn't correct that error. And in that case, it was determined they shouldn't get the credit because that was kind of an error on their part. Next, we have the Newkirk case, and in this case, there was the defense was seeking credit in the amount of $6,587.79. The credit was awarded, and the applicant appealed, and ultimately the board rejected this appeal. In this case, there was really, it's an example of one of the sort of basic situations that we see where the overpayment was really not the fault of anybody. And so the credit was, I'm sorry, I totally lost my train of thought. And so in those situations, the award could be appropriate.
But in this case, it was denied because it would have wiped out applicant's award. And that was the big issue here, because they don't want the entire PD award wiped out by the TD overpayment credit.
Right. Okay. And then finally, we get to this final case, Pacheco versus Taco Station. Okay, in this case, the overpayment was due to the permanent and stationary date being given retroactively by about 5.5 months. It was not due to either party acting in an inappropriate or bad faith manner. And so originally the credit was allowed, but ultimately it was decided to send the case for reconsideration because the court, when making that determination to allow the credit, did not consider some of those factors that we talked about earlier from the Maple case, some of those equitable factors. And so it was determined that you know, that it should be reconsidered, especially because it did wipe out the PD. All right, I'll let Chantal take over.
So we wanted to give you guys some of the big cases that have come down on TD overpayment credit, so you have them for reference, and you can kind of see how the court has ruled on them. Since you know, I wish we could give this presentation and give you guys a magic answer on, okay, this is how you get credit, but unfortunately, because there's so much discretion involved, each case is going to be very fact specific, and the judge is going to have the discretion to decide. So any case that's litigated before a judge, it's going to be fact specific. And so we can't give like a magic formula other than be sure you follow the rules, be sure there's no fault, be sure you file your petition for credit. And then, you know, that's the relevant case law. But now we want to move back to a little bit more practical stuff on how do we actually handle these in practice. So what happens after the petition's filed? So you file a petition for credit, you know, you may or may not be at the end of the case. And sometimes the applicants object and sometimes they don't, which is interesting, but it does happen. So I have had cases where I file a petition for credit, applicant's attorney does not object, and a couple weeks later in the mail, I get an order from the judge ordering the credit. That's not the norm because it really is a triable issue, but I have had it happen. Typically they will object and then now it's a triable issue. If tried, it's usually deferred to the end of the case to be tried with the case in chief, partly because the credit would come out of the benefits. And if you haven't finalized what the PD is, then it's more difficult to actually administer. And then also because of judicial economy, the judges aren't going to want to hear a trial on a petition for credit and then later have another trial on the case in chief. And then neither do defendants. I mean, you guys don't want to pay for 2 trials either. So it makes sense to defer the issue of the petition for credit to the end of the case. And you just have to make sure that you and your defense attorney remember to list it as an issue on the pretrial conference statement so that it does get adjudicated with the case in chief. And that way, when the judge is issuing a findings and award at the end of the trial, they'll say, okay, here's the permanent disability, here's the credit, and you would pay according to the award. So if the credit's ordered, the TPA or employer administrating the benefits would apply the credit to future benefits pursuant to the order. You've got to make sure you follow the order. I have come up with situations where we filed the petition credit for one number that we calculated, and then the judge has ordered a different number that the judge calculated differently. So you want to make sure you're not just going off your petition, but you're going off the order, because you have to pay the order in order to avoid penalties and sanctions. So I just made up this little example here. If it goes to trial, the judge fines 15% PD. That's $14,645 at $290. So if you're awarded a $2,000 TD overpayment credit, then the TPA would pay both after receipt of the award, thus paying applicant $2,000 left, $12,645. That's if that matches the order. So again, this is going to be very fact specific. So if you're working with a defense attorney, make sure you work with them on how to actually administer the credit, but this would be the basic situation. If the credit's denied, no credit can be taken unless an appeal is filed and then it's awarded. So we've already talked about, like, no, you cannot take unilateral credits, and this is the same. So just because you filed a petition doesn't mean that you can take the credit until it's actually awarded. So realistically, we know that we settle a lot of workers' compensation cases. Not all of them go to trial. So practically speaking, how do we handle these at the time of settlement? you can take credits for TD overpayments in a CNR or in STIPs. So I've had this happen where I filed a petition for credit, applicant didn't object, the judge ordered it, so we just put it in the CNR, done. Then the judge is going to approve the CNR and you're going to get an order approving. So now you actually have 2 orders for the same credit. That's not necessary if you file a petition for credit and no order issues, and then you're negotiating with applicant's attorney and they agree to the credit, you put it in the CNR and then the judge approves the settlement and now you have an order. So now it's okay to take the credit because the order addressed it within the settlement. Obviously, to do this, both sides have to agree. So this is negotiable, just like the value of the case. So I typically handle this by putting it out there right at the beginning. So if we're making a settlement, you know, applicant demands $100,000, we counter at 50, but I will say, you know, we'll do 50 less the TD overpayment, less PDAs, you know, and no voucher or whatever it is that we're negotiating at the time. And by putting it out there early, applicant's attorney knows, okay, hey, they want this credit. And then it's something that we can address while we're negotiating. They may say, no, I don't want the credit. Absolutely not. And we'll fight over the facts of it. Hey, look, there was no fault of defendant. My client received it on this date. They cut off TD at this date. You know, if we take this to trial, you know, it's not overly large. It's not going to wipe out PD. This is legit and we're going to get this. Sometimes they'll give in and sometimes they won't. But another option is to compromise, just like we do with PD. And so another way to get at least some credit for the overpayment is to negotiate a compromise. There are a lot of situations I've run into where they are willing to split it. So if you say, okay, we have a $2,000 TD overpayment, there's no fault on defendant's part, neither one of us wants to pay for a trial on this, how about we split it and we'll do $1,000? Then we include that $1,000 credit in there, and that's at least something that you're getting back, even if you didn't get the full amount. So that is something that we'll use. And then I had another case recently where applicant's attorney was vehemently opposed to including the credit. His client was really angry about it, even though there was no fault of defendant and it didn't wipe out the PD award. And we were talking settlement at 80,000, and he said, I can't include the credit. My client's too sensitive about it, but I will CNR for 70 with no credit included. And so it's obviously $10,000 less. So you're kind of getting the credit in a different way. My client was on board with that. So that's how we kind of got the credit without getting the credit. But that depends on the specific client. I know there's issues with audit and rules that the TPAs have to deal with. So that's not always possible, but I think in practice, the best way to actually get a credit is to be creative and to work with the applicant's attorneys in negotiating. And it really helps to have filed that petition for credit. There have been many, many times where I'll, in negotiating, say, hey, you know, we want less the TD overpayment credit. And they say, well, did you file a petition under CCR 10555? And if I can say, yes, I did months ago, and you didn't object to it, that now gives me a leg up in negotiating to get at least some of the TD overpayment credit considered in the settlement. So make sure that you get those TD end notices noting the credit sent out right away. Make sure your defense attorney gets a copy of it, and make sure that they're filing those petitions for credit. If I get a TD end notice, I always look to see if there's an overpayment noted, and if there is, I immediately file a petition for credit. We may not get it later. It may not be something that we can recoup, but I always file it to cover our bases and use it in negotiating later. So practically speaking, I thought it would be nice to show you guys how this is included so you can see it. You can see in the CNR is great because it includes a specific line just for a TD overpayment, if any. So you put the settlement amount, you put the permanent disability advances, you put the TD overpayment. If you have an MSA, you can put that here. You put the AA fee, boom. It's super easy. It's very obvious. There's no hiding the ball here. And then the judge would approve it and you'd have your order. This is a very simple, very practical way to get your TD overpayment credit without having to litigate it. And you can also do this within STIPs, but it is a little less clear. So within the STIPs, you can see I highlighted in yellow where the TD periods are listed. You're going to want to put the specific dates and the amounts paid here. And so the way you account for the credit on the first page there, which is page 6, I know that's small, is you want to make sure it say TD was paid through June 15th, but applicant was P&S June 1st. You would want to say there TD paid through June 15th, and that would be the date that you note. But then under line 3, where it says PD, the injuries caused permanent disability of blank % for which indemnity is payable at blank rate per week beginning. You would want to put June 1st there, not June 16th, because if you put June 16th, you're saying, okay, I paid TD through June 15th. I'm picking up PDAs June 16th. But here we want that overpayment. So you want to put, I paid TD through June 15th, but PD starts June 1st. And now you've captured that TD overpayment period within the dates of your STIP. An applicant's attorney is going to sign this and STIP to it. Technically, that would probably be sufficient to account for it, but I'm always cautious that applicant's attorney will then say, well, I didn't realize, I didn't know you were doing that. And we don't want to be unethical. And also we don't want to have to then relitigate this, have it set aside and say, oh, well, this was not what we agreed to. So on page 7 in the STIPs box, I always add language there that we're stipulating to the TD overpayment. So I would say there's a TD overpayment from June 1st to June 15th, paid at a rate of this for a total of this. Defendant is taking a credit against permanent disability for the TD overpayment of X dollars. And then applicant and his attorney or her attorney are going to sign just below that. So there's no games, there's no confusion. We're taking that credit. And then when you're paying out the PD after, we sign this, we submit it to the board, the judge issues an award of PD. You're administering it. Now you get to take your credit because we stipulated to the periods, we stipulated to the rate, and we stipulated to the TD overpayment credit within the settlement. So it can be done in both situations, a CNR or a STIP. The CNR is just a little bit easier with its own specific line just for that. Whereas the STIPs, I think you have to be paying a little bit more attention with the dates. And then I like to add the STIP into paragraph 9 for the comments box. And just as a practice note, when you're doing STIPs, I often will see STIPs where the dates are wrong or the dates listed here don't match the notices. So you're always going to want to be extra careful that your dates and your rates and your numbers in these STIPs match what you actually paid. Sometimes the TD notices are wrong. Sometimes BPOs, maybe you have 2 claims and only 1 is listed or something. You want to make sure you're accounting for all the benefits you paid, because once you STIP them here and an award issues, that's what they are. So just be careful with that. Make sure you're getting your defense attorney the notices and the BPO and making sure that everything is accurate before it's filed with the board and signed by everyone involved. So that is kind of the end of the bulk of this. We wanted to leave plenty of time for questions for everyone since this is a hot topic. And again, I hope we provided some practical advice on how to handle and actually get credit for these overpayments, even though a lot of it is left to judge discretion. So please jump in with any questions. Diane, are there any questions?
Yeah, we do have a few questions. Hold on for a half second,
great.
and I will get those to you.
Awesome. I'm glad we finished with a little time for that.
All right, let's see here. By the way, somebody said they were very happy with RGTGR, especially with a few of your people in the firm. They've had very good results.
Oh, so, thank you.
That's very nice of Amy. You put that in there. Okay.
Yeah, thank you, Amy.
What if the EE did RTW but continue to receive TD, is EE legally obligated to reimburse the carrier?
So TD's paid, applicant returns to work, and they're getting paid again. That's what you're asking? I mean, I think that's again a petition for credit situation, because the TPA should be in communication with the employer that the applicant has returned to work. So as much as double dipping is completely unethical and they should know better and shouldn't be doing it, the employer also should be letting the TPA know that applicant has returned to work full duty. So I don't think they can unilaterally take that credit there either. You would still have to file the petition for credit and it would still have to be accounted for. I guess in theory, applicant could choose to reimburse the TPA, but most of the time that money is gone, and they're not going to have it. So then practically speaking, you're going to have to get it ordered against the PD, because not many applicants who are double dipping are also going to have just money they're sitting on to then write a check to the TPA.
Makes sense. Okay, another question. Can we unilaterally take a credit against the same species of benefits?
That is a really great question. So you're saying you overpaid TD, and then, I mean, I guess it would be really fact specific, because you're saying you overpaid TD. Why did you stop paying TD? And then they're getting TD again. So I'm guessing this is a return to work situation, or it could be a PNS situation where then they have a subsequent surgery so that they're getting TD again. Frankly, I don't know the answer to that. I would have to look it up, and I don't want to give you incorrect information. And more than likely, I think it's going to be very fact specific on why the benefits stopped to begin with and then restarted. Because I have had a lot of situations where applicants TD, somebody releases them and says they're fine, and then they end up having surgeries and they're TD again, and then the QME says, no, they were TD the whole period. And so then a lot of the times where I've seen those situations where there might have been an overpayment, it ends up getting wiped out later because someone else will say applicant was actually TTD the whole time. So the question is, why were they no longer TTD, and is that substantial? Is that going to hold up in court? That's going to be really fact specific. So I know I didn't answer your question, but I would be happy to look. I don't know who asked that. If you want to email me, I can look it up and get you a firm answer. But even if I get you a firm answer, it will be fact specific.
Okay, so why don't you give your email address real quick? So
So on the PowerPoint here, there are the different offices. So if you're at a specific venue and you want someone from that venue, email those. If you want to email me directly, that's totally fine. My email is Chantal, spelled on the screen there, CHANTAL @rtgrlaw.com. And Sarah's is her name, Sarah, S-A-R-A, but then she is a J. So Sarah J @rtgrlaw.com.
Okay, excellent. Okay, if the claimant is pro per, we would then need to file an application to address a credit for overpayment issues, correct?
Yes, unfortunately. And the other thing that you're going to want to be very careful of is not filing a DOR, because if they go get an attorney, I'm sure you all know this, but I'm sure if you file a DOR and then they go get an attorney to handle that hearing, now you owe attorney's fees for that hearing, which they're of course going to charge at $450 and 1,000,000 hours. So this is a situation, any pro per, you want to tiptoe carefully with any litigation, so that you don't get yourself into that situation. If they file the DOR, it's different. So unfortunately, yes, you would have to file an application, which you can file the app without triggering the exposure for the AA fees. And then you could file the petition. And then the question is, what do you do with that? And that would be either down the road, it gets litigated, or you address it at the time of settlement. I have had that happen with pro pers, and I had a case just recently, actually. We CNR'd, and there was a TD overpayment credit included in the CNR, and the judge approved it. And that's because the settlement was large, the TD overpayment was small, there was no fault on the part of the defendant, And actually, there was no petition for credit in that case because I didn't have the file until the very end. I was just doing the CNR, and the adjuster did not file a petition for credit. But the judge still approved it because it was included within the CNR. So that's kind of the one caveat as to when you can get an overpayment awarded without a petition would be within the CNR. But if applicant has an attorney, they're never going to let you do it if you haven't filed a petition for credit. So it's kind of it's always safer to just file the petition, but you can include it within a CNR for a pro per, and it's just going to be very fact specific if the judge approves that or not, and if the CNR is adequate. And this one, the CNR was over $100,000 and the TD overpayment was like $300. So that one was easier. But yeah, unfortunately, the petition for credit has to be filed unless you do it at the time of settlement.
Okay, so here's a question. It says, can we take a credit for TD overpayment at the tail end of PD advances prior to filing a petition for credit?
No.
All right.
That's the short answer. No, unfortunately not. Not under the new regs.
All right, for unrepresented employees, do you have to file an application first before filing a petition for credit?
Yes, you can't file a petition without an ADJ. So unfortunately, you would have to file an application to get that ADJ to then file the petition for credit. So this is very similar to the case we're just talking about. I mean, do you want to file the application and the petition right away, or do you want to wait and see if you can include it at the time of settlement? It's a toss-up because it depends if they get an attorney. You could also just wait until they get an attorney, and then when you get your DA, say, hey, by the way, there's an overpayment, please file a petition immediately. So it kind of just depends on how you want to handle that, but you can't file a petition without an ADJ.
Okay, here's another question. It says, is a petition for credit necessary if the credit issue is listed on the pre-trial conference statement with the date and the amount of the overpayments?
That, I would say yes. I've never seen it come up. So again, that's going to be super judge specific. The regs require a petition. So if you don't, I think that's super risky. If you put it on the pretrial conference statement, but you don't have a petition filed, you run the risk that in the F&A, the judge says there's no petition to adjudicate, you did not comply with the regs, therefore it's denied. So given, I mean, you guys saw how short that petition was. It's 2 pages long. It makes a lot more sense to file it, even if you're filing it the same day as the pretrial conference statement, just to ensure that you're complying with the regs and that a judge isn't going to deny you. Now, we all know that the boards like to say that there are no local rules, and we all know that they have a million local rules, and not only do they have local rules per each board, they have local rules per each judge. So if someone is practicing in front of a judge that they know the judge will let you try the issue just based on the pretrial conference statement, I suppose you could do that. But I would also think that you'd open yourself up to a basis for an appeal there, because the regs say you have to file a petition for credit and specifically what has to be included in the petition. So that's a pretty good basis for a petition for reconsideration if the judge awards it and applicant doesn't like it. So personally, I wouldn't do it, but yeah.
All right, so what if they are being advanced PD and they have significance about PD, but there's an overpayment of approximately $17,000?
So you're afraid that you're going to advance all the PD and then there's going to be nothing left to take the credit against? I'm guessing that's what you mean. I'm not totally clear on the question. Yeah, that's a risky situation. I think, sorry, I'm thinking this one through. So if you're advancing PD, you're obligated by law to advance reasonable PD. I think you could try to say your PD equals this, and well, I don't know, it kind of, this one's tricky. I think you're probably stuck having to still advance PD at least a reasonable amount. so that you don't open yourself up to any penalties for not advancing reasonable PD under that regulation. And yeah, you might end up wiping out and not being able to take the full credit. A $17,000 credit is huge. So unless there's really high PD, you're probably not going to get it anyways, or at least not all of it. So that would be one where you'd want to file the petition for sure because it's big. Examine to be sure there's no fault. And then that might be one where you try to CNR and get a compromised credit value in there because you're probably not going to get the whole thing. If you want to talk to me about that separately, you can email me because I didn't fully understand the question. So yeah, if you want to email me separately, go for it. I'm happy to respond and provide educational information, not legal advice.
All right. So some carriers convert TTD overpayments and recode it to PD. Are you stating that this can no longer be done whether the claim is litigated or not?
Yeah, I know carriers do this, and I think, again, this is really risky because you're basically doing the same thing as unilaterally taking a credit, but you're doing it in a different way. So I would not recommend doing that because if a judge found out, you could get in trouble for that. So, I mean, it kind of depends. I mean, you're recoding them. So on the BPO, it's going to look like PDAs. If applicant is wise to that, if AA is wise to that, that's risky because you're unilaterally taking the credit without a petition or an order. You're just doing it in a different way. So I would say that's a no. I would certainly not recommend my clients do that. I know it's been done before. I've had tons of cases where people did that pre-2020. I would say that was probably the norm, but post-2020, I would not do that.
Okay, is it okay to only put it in the CNR and not file for a credit before? So
Yes.
only the CNR language is addressing the credit.
Yes, we have done that many times. You can, because the credit is noted in the CNR and the judge is ordering it. So it kind of takes the same effect. The only catch is that if applicant has an attorney, when negotiating the CNR, if you haven't already filed the petition, they may or may not agree to it. It's very AA specific. I have some AAs that will never agree to a TD overpayment credit, and then others that do. So it kind of just depends, but I do find that filing the petition gives leverage in negotiating. If you're not negotiating, I think it's fine, but you know, always err on the side of caution. If you can file it and get it done, do it, but it does still count and it's still a valid credit if it's included in the CNR and ordered by the judge, even without the petition.
Okay, what is your experience when the settlement will include an MSA? If we don't get a decision on the petition prior to settlement and make PDAs, where does the credit come from?
Well, so the credit can only come from PDAs. It cannot come out, or from PD. It cannot come out of the MSA. So I wish I could read that question. I'm so visual. I'm sorry.
If you go to questions, let me see here.
I can't see them.
Yeah, they're really small.
That's okay. I'll try to answer it. So yeah, I mean, you cannot take the credit out of the MSA. Nothing can come out of the MSA. AA's fees can't come out of the MSA. So sometimes I've had situations where we've actually had to increase the CNR because we didn't have enough to cover AA's fee with the MSA. MSAs complicate everything, as you all know. So you would have to find a way to take it out of the PD, but then that might wipe out the PD because a lot of the times we get a case with like a 10% PD, very low, you know, that's like right around $10,000. And then you have an $80,000 MSA. So you're like, oh, well, it's a $90,000 CNR. We should more than be able to cover it. But the reality is, if you have a big overpayment, you're going to wipe out the entire PD and the judge won't approve it. So it's more complicated with an MSA because the CNRs where we're valuing future med, is different because that money has to be set aside for Medicare. So I hope I answered the question. If not, email me. But ultimately, yeah, you cannot take the credit out of MSA.
Is it appropriate to take a credit for TD overpayment without an order if the claimant is with the police department?
Without an order. I don't know why that would make a difference. The regs don't delineate between type of employment. I know police officers have 4850 and TD, but I still don't see why you would be able to take a credit without an order. If the claimant is with the police department. Yeah, I don't see why that would make a difference unless there's more going on there. Because the regs just address all applicants, not a specific type of employer.
Okay, in Newkirk, you wrote, the WCJ awarded this credit and the applicant appealed, which the judge rejected. Please, did the WCAB reject the appeal or the credit?
The credit, because it would have totally exhausted applicant's permanent disability award.
Okay. It says,
That's right, Sarah, right? That's how I read it. Is that how you read it as well, Sarah? I'm sorry, you're muted. Okay, yeah, she said yes. So, so yeah, the WCJ at the lowest level awarded the credit, applicant appealed to the WCAB, and they rejected the credit. I'm sorry, that wasn't clear, as opposed to the appeal. Yeah, they rejected the credit because it would have totally exhausted the permanent disability indemnity.
All right, so Sarah, you're unmuted, so if you wanted to participate or answer questions. The question, I have a question regarding 15% to AA regarding TD.
Okay.
That's the whole thing.
Oh, that is the question. Okay. I'm not sure exactly what the question is, but I do know if AA files a DOR and you're litigating TD, typically it's retro TD. So we didn't pay TD for whatever reason, and AA files a DOR, they want retro TD for a certain period. If they have to litigate to get that, typically we're going to compromise, but even if you go to trial, they get 15% of whatever that is. So let's say there's a retro TD period and the TD is $5,000, the retro TD is $5,000, and we go to trial and lose, the judge is going to order us to pay $5,000 in retro TD less 15% attorney's fees. So you're still only paying $5,000, but 15% of that $5,000 goes to AA. We do the same thing in STIPs at the board. So if we show up on trial day and AA and I are arguing and the judge weighs in and says, oh, no, I'm going to award this, we might just stick to it rather than submit the issue for adjudication. So if we stip at the board, you write on the little stip and you're going to say, we agree to pay this retro TD period from X date to X date at a rate of this for a total of $5,000 less 15% attorney's fees and the amount of this to AA. And so AA is entitled to 15% of TD when there's like a litigated issue. So if we're just administrating benefits and paying TD, they don't get anything of that. It's just if they have to do some work to get it, then they get 5% of whatever that, 15% of whatever that amount is. I'm guessing that's what you were asking about. So if that's not, and you have a subsequent question, feel free to let me know.
Well, we are at time. There are some questions and I will make sure that you get a copy of those. And if you get a chance, email those back. We did have a few ideas that people gave for future webinars. Thank you. I will look at those. One of them was on negotiating settlements, some tips and tricks. We actually are going to be doing an event in the Sacramento area on November 9th with Carl Van, who is a claims expert, and this is one of the topics he's going to cover. So if you're in the Sacramento area, make sure you look out for that in-person conference. Well, we are out of time. I'd like to thank you all for participating. I'd like to thank our experts today. Thank you very much. You've generated more questions, I think, than any other webinar that we've ever had. So people are interested. And again, if you didn't get your question answered, I will be passing those questions on and hopefully they can get back to you. Until the next time, thank you very much for joining us and we'll see you at the next webinar. Bye-bye now.